It's lawyer Lisa Merrill, October 25th, 2022, and I wanted to review the Honorable Justice Ralph Porzio's decision that was released October 24th in New York State. And I wanted to do it because it analyzed whether or not certain orders requiring first responders, etc., needed to be bleeped in New York, and whether or not their employers could fire them. Well, spoiler alert, they could not. And that those orders of the Commissioner of Health and Mental Hygiene dated October 20th, 21 was arbitrary and capricious. That the order of the Commissioner of Health and Mental Hygiene dated December 13th, 2021 was also arbitrary and capricious. And that the Mayor's Executive Order number 62 was arbitrary and capricious. Now, like, share, and subscribe, and hit that little bell. Now, most often, there is an analysis of this case, and that has been very positive out there, and that this could be a watershed case. I like that. I want to analyze it specifically in relation to the College of Ontario, the College of Physicians in Ontario, and their Bleep 19 frequently asked questions for physicians. Now, this is how they're instructing their physicians, and it was updated on June 29th, 2022. So if I stated, for instance, instead of the word patient, but Judge of New York State, or Judge of the State of New York, how would you think of this statement? Okay, I'm going to prove that the physicians in Ontario would be instructed to find this man insane, or at least requiring medication, right? Ralph Porzio should not come to Ontario to be analyzed by a physician in Ontario. He could possibly be referred to psychotherapy or find himself with a prescription that he is ill-advised to take, I would say. So, I'm going to quote now. It is important that physicians work with the Judge of New York State to manage his anxiety related to the bleep and not enable avoidance behavior. Put back here. Or avoidance behavior of first responders in New York, or anybody else who's going to use that decision in their briefs of authority. Lawyers who are going to present and use that decision in argument. No. Bad Ralph. The physicians in Ontario would not like you. I'll go back to that frequently asked questions. In cases of serious concern, responsible use of prescription medication and or referral to psychotherapy are available options. Overall, for that judge, for judges of New York State, they are terribly at risk here. Overall, physicians have a responsibility to allow the judges of New York State to be properly informed about bleeps and not have those anxieties empowered by an exemption, or for that matter, a decision that a lot of people are going to use going forward. So let's look at that decision. And some of the more considered wording, or all of it was really considered. He reviewed a lot of decisions. He reviewed a lot of case law, it looks like. He quotes some statutes. What did the College of Physicians quote? I wonder if they had due process. I don't know. So he found in his conclusion, it is clear, and I want you to look for instances, maybe some breaks with realities, some indications from a physician's point of view that this man might require psychotherapy, okay? I wonder if any physicians out there are going to say this man needs psychotherapy. You can comment below. I would love that. Like, share, subscribe. It is clear. This is page 11. It is clear that the health commissioner has the authority to issue public health mandates. No one is refuting that authority yet. However, the health commissioner cannot create a new condition of employment for city employees. The health commissioner cannot prohibit an employee from reporting to work. The health commissioner cannot terminate employees. The mayor cannot exempt certain employees from these orders. Executive Order number 62 renders all the blip mandates arbitrary and capricious. Being bleeped does not prevent an individual from contracting or transmitting the bleep 19. Has anyone else noticed that? Like, is this yet part of your common occurrence? Like, can you take personal judicial notice of that fact in our society? As of the day of this decision, CDC guidelines regarding quarantine and isolation are the same for the bleeped and unbleeped individuals. The petitioners should not have been terminated for choosing not to protect themselves. We have learned through the course of the pandemic that the bleep against bleep 19 is not absolute. Breakthrough cases occur, even for those who have been bleeped and boosted. President Joseph Biden has said that the pandemic is over. He has a little footnote there with the number 8. The state of New York ended the bleep 19 state of emergency over a month ago. Okay, so he goes on to say the bleep mandates for city employees was not just about safety and public health. It was about compliance. I'm going to read that again. It was about compliance. He's right. If it was, he goes on to say, if it was about safety and public health, on-bleep workers would have been placed on leave the moment the order was issued. If it was about safety and public health, the health commissioner would have issued citywide mandates for bleeps for all residents. In a city with nearly 80% bleep rate, we shouldn't be penalizing the people who showed up to work at great risk to themselves and their families while we were locked down. I would like the Ontario College of Physicians to either say this man is insane or to retract their frequently asked questions. They seem like they are captured. And I, just for the record, believe that the Honorable Justice Ralph Porzio should not come to Ontario. I would love a cup of tea with him, but he should not come to Ontario. Have a great day.